Welcome to Channel AMAC, your insight to the Australian visa system. Good day everyone, my name is Carl Young, your online YouTube visa consultant. Are you interested about migrate to Australia? Why don't you consider to subscribe to my channel and turn on the bell on the side, so once we have all the updates and news, you'll be the first one of getting all the insight. Okay, today's video, we'll like to discuss a little bit of detail in regards to all the parent visas. So if you already migrate to Australia, obviously you would like to have your family united in Australia as well. That's no doubt, and I've been receiving inquiries all year long and answered a lot as well. Now I've decided to do in this video to actually explain this detail, which I do not believe in my previous record I had actually done any explanation on this one. Now obviously you have clicked it into the thumbnail. It's all about the word and the definition of settled. Now obviously if you have just arrived in Australia with perhaps a permanent residency, skill migration, subclass 190, 189, or whichever the visa category that gets you permanent residency. Now you wanted to get your parents perhaps to come to Australia to unite with you as well and live in this wonderful country. What do? Obviously you are a child of your parents, that's for sure, and we've gone through a bit about the balance of family tests in the previous video, which I've probably done 2 or 3 years ago. Now today we're going to talk about the definition of settled, because a sponsor has to be a settled Australian permanent resident or Australian citizen, else you cannot actually sponsor your parents. Let's have a look, and I will direct you to the immigration web page. As you can see from the left side of the screen, that's subclass 143. It's the same for 173. And it's also the same with 864 contributory age parent. So the differences between age parent and parent visa is obviously aged. Now the current changes in regards to whether it's age parent or not age parent is, I think, it's around the age of 67, but anyway, it changes every year, depends on how the Centrelink and the government views it, and you need to get that updated. So what are we looking at? We're looking at if we could toggle this and then change it to sponsor. As you can see with my cursor, and I go to eligibility, you will see how a suitable sponsor can be in order to validly sponsor the parents, whichever country that those parents are in. And we can see with the tiny words here, it's very minor, simple stuff, but still very important. As you can see, the second point here, it says settle in Australia. So obviously we won't discuss the detail and the definition about how they meant by that. If I have just arrived and live in 1 day, is that settled? If I just arrive in 3 months, bought my own house, and living in Australia, it doesn't count as a settle. We'll have a look at that one. And also it's the same across with contributory age parent as well, and all the other parent visa apart from 870, which is a different one. Now again, if we toggle this to sponsor and we go to eligibility to be suitable to sponsor, again you will see the second point with the word settle with the link there. So I've actually clicked it in there, and I will actually show you on that one. So in a nutshell, you need to be settled. So by means, the government of Australia wanted to check that you are actually permanently living in Australia. They don't use permanent because they don't want to have that different meaning and go and cross between permanent living or permanent resident, because it's just too confusing. So they choose the word settle to be aligned with that criteria there for the parent sponsor. So the test here is that the government of Australia wanted to confirm that the person living in Australia is actually permanently living in Australia, not holding a permanent residency PR, but living somewhere else, not holding Australian citizenship or passport, but living somewhere else. So they are actually a tax resident, should I say? Because if you become a tax resident, obviously you live permanently in Australia, and that's the test that the government wanted to check. So let's go through the actual definition here. So if we go to, let's just go back to here, and everybody can access to this one. So all you need to do is click on that, the link thingo and the settle there. Now I don't know why in the subclass 143 it's not blue, but once I click on that, it does prompt you with the definition there. It says we consider settle. As you can see, you may read this. I'll read it out. It's quite little. We consider settle if you have lived lawfully. So if you have lived unlawfully, by means you probably don't even have a visa, that doesn't count. In Australia for a reasonable period, usually at least 2 years, and are Australian citizen, Australian permanent resident, eligible New Zealand citizen. Eligible New Zealand citizen is another thing that I really haven't really been explained. It's the Kiwi holding the Kiwi visa, a passport, I'm sorry, and have arrived in Australia and living in Australia permanently before 2001. I think that's the year there. In compassionate and compelling circumstances, we might consider Australian citizens settle after 3 months. Now let's go into the subclass 186 with the the actual link there. So I've clicked on it and go through to the glossary web page, which I should magnify a little bit larger. Here we go. That's a better. Okay, so let's have read. That's exactly what I have just read from the prompt of the subclass 143 page. So we consider settle, have lived lawfully in Australia a reasonable period, usually at least 2 years, and who is Australian citizen permanent resident. Okay, now how do we define and how do we utilize this by law? So giving you an example, if one person had been international student holding a lawful visa, for sure holding a student visa, graduated with a graduate work visa for A5, and then got recently invited to become a permanent resident and got granted subclass 189, congratulations. Now on that date of the grant, he or she become the permanent resident, so that meets this criteria. And then we going back and see, okay, has this person, he or she, lived in Australia lawfully for at least 2 years? Now, yes, question is yes, because he or she has been living there with 405 visa and also lawfully with the student visa as well. So then that would mean the requirement, and straight away that graduate, that newbie, could actually sponsor his or her parents straight away. Now, give you another example. Now, if this guy is a high-tech guy and just received an invitation to lodge the Global Talent Independent Visa subclass 858 and subsequently got granted yesterday. Now, he's pretty happy. He's planning to fly into Australia next week and had already looked into a house to purchase for a new home. Okay, so the day that he arrived in Australia, does he count that status as settled? So obviously he meets the second criteria, as he is a permanent resident because he's got that GTI visa, that's a permanent residency visa. But has he lived lawfully? Well, he hasn't lived unlawfully, but he has not been residing in Australia for 2 years. So that means he will not be eligible, not suitable to sponsor his or her parent. So that's the differences there. I wanted to give you a very quick sample example to explain how this simple tiny word within the regulation could change a lot of things. But anyway, should you have more question, query, more than welcome to leave comment right down below, and I'll see you next video. Goodbye.